It's a great pleasure, a personal pleasure, and a pleasure for Diritti Comparati to have today Professor András Sajó, that is one of the world's most prominent scholars and professor in legal theory and comparative law. I will not speak so much about his curriculum, but let me just remind you that he was the founding dean of the legal studies at Central European University, and is a distinguished, prominent also scholar in constitutional law and human rights fields, including media regulation. We will come back to the media regulation. András, Professor Sajó, is a former vice president of the European Court of Human Rights, and was extremely and extensively involved in the legal drafting through Eastern Europe, especially in the founding period after the fall of Berlin Wall. So in the 90s, it was very involved in many also policy making process. Just let me remind you that he was a counsel. He served as a counsel to the President of the Republic of Hungary and chaired the Media Codification Committee of the Hungarian government. He was also one of the principal draftsmen of the Environment Code of the Hungarian Parliament, and he was the founder and speaker of the Hungarian League for the Abolition of the Death Penalty. He's a member of the American Law Institute and is in the Hungarian Academy of Science. Just let me quote a few of the many distinguished universities where he served as visiting professor: the Cardozo Law School, New York University, University of Toronto, University of Chicago, Columbia University, and luckily we are really lucky to have him visiting professor also Bocconi University recently. Now, I would like just to start with a personal note. I remember that it was more or less 2005, 2006. I was in Parma for a conference, and I had the lucky to hear Professor Sajó for the first time speaking. It was not only charismatic, but was very careful listening to the young student or researcher request. He has been very kind, not only with me, but with all, let's say, the younger researcher at that time and now, in order to give guidelines, to give suggestions in a very informal way. And this is very striking in the light of his incredible academic standing. This was one of the things that I appreciate more in this, let's say, that if I can call friendship, or for sure admiration. But now, leaving beside a personal note, I was the first time caught and impressed by the reading of one of his most famous book. We will come back to the last book, but Limiting Government: An Introduction to Constitution is to 1999. My question would be, how it's possible to connect, if there is a connection between this first attempt to try to describe which should be the way to limiting government. And I like very much, if I'm not mistaken, your dedication in that book to whom tried to obstacle the writing of that book, but correct me if I'm wrong. And which is the connection between that book, that scenario, that context, and then the most recent context that in a way brought to the latest book published in 2022 for Cambridge University Press, Ruling by Cheating. There is a connection, or there is not. In any case, it would be nice to start from that perspective in that book, and then trying to find the possible bridge in order to also tell us a few words about the new book and the implications of the phenomenon of governance in illiberal democracy. Thank you very much, Professor Sajó.
Thank you, and thanks for the kind introduction. Talking about the early book which appeared in English and some other languages in the late 90s. This was a book that I wrote earlier in Hungarian, and it was related to the transition. Came out of my experience in communism, where power was unlimited. And to me, constitutional law and constitutional arrangements were primarily about, as the title indicates, limiting the power of government. Because I thought that this is really the main problem with state organization, that it is unbound, or it tends to be unbound. Even if it is democratically elected, there will be, without proper institutional constraints, this may turn against the citizen. So that was the main idea. Was, in a way, it was very old-fashioned at that time, because people in my profession and in politics were more interested in positive functions of the state, which I'm not denying. I admit that Constitution is also about social cooperation and shall provide a proper frame for cooperation. But to me, a constitution is primarily a defensive tool, because social organization may occur in many other ways. Law is secondary. It just gives some assurances to existing cooperation. And really, it's a protective mechanism. So once again, this reflects the experience of someone who lived in for 40 years in a world of oppression, and thought that one should, it's better to be suspicious, not to fear the government, but to be suspicious. Now, unfortunately, this last book, which basically I wrote 30 years later, Ruling by Cheating, that's the title, describes what is called illiberal democracy. Political scientists call it hybrid regime. There are electoral democracy. There are many names, but basically this is the kind of phenomenon that grows out of populism turning into plebiscitarian leader democracy, and from plebiscitarian leader democracy into some kind of personal quasi-autocratic rule. But illiberal democracy is halfway to that. And it's also, importantly, a technique of government. Now, what you see here is that, again, power is concentrated and then abused. And so there is a continuity, and it's very unfortunate that my original suspicions or embedded suspicions unfortunately are still making sense. And they do make perfect sense, I'm afraid, because these new illiberal regimes, they concentrate power and abuse power, but they use it under the pretext of constitutional arrangements, under the pretext of the rule of law. So one has to be particularly attentive. And I think this last book is, again, about a specific constitutional attentiveness.
Thank you very much for this, because in a way it shows how suspicious can in a way be very connected to attentiveness. And then there would be another question. Once that there is the suspicious, then there is the careful, let's say, analysis of a process and the identification of illiberal humus. What then, which is at the time then the role of the constitutional scholar? I mean, from a socially, more than from a scholar point of view, from a social and cultural point of view, which should be the let's say the basis of the reactions of a scholarship when this is first of all suspected, then identified, and then which should be then the next step?
Well, if I would be in politics, I think, if I were to know the answer. And I would be in politics because, in a way, the situation is so dramatic. I mean, I never had much of a political ambition, but, you know, when you are morally outraged, very little remains other than politics. And the problem is, if you are going into politics, what kind of policy you advise and follow. And that's where I have difficulties. But anyway, leave my problems aside. So seems to me that we are not yet fully aware of what's going on. So there is still a lot of work to be done by a scholar before getting engaged in real political action. And what is not known, or let me rephrase, I think that in this post-material world, in that part of the world that moved into a post-material state of mind, the fundamental assumption was that there is a reason to trust, at least to some extent, government, authorities, public institutions, cultural phenomena, and so on and so forth. And we know, and this is pretty much mainstream scholarship, that building trust and relying on trust is very efficient, cost efficient. I mean, that this is the right thing to do. Behavioral economics or rational choice, game theory, it's all about cooperation, and good intentioned people preach the beauties of solidarity and cooperation. And that mentality, I'm afraid, made people a little bit naive, too credulous, and they lost to some extent, many of us lost the critical attitude. So there was a period when we took words for granted, promises for granted, moral commitments for granted. And then we got disillusion suddenly because all these promises of network democracy, social media democracy, they all seem to have the opposite what their potential offered. I remember 15 years ago, I wrote very enthusiastically about referenda through internet. Fortunately, this was never translated into any language, so I just confess this at this moment, that I know from my own experience that the possibilities made me blind at the time to the shortcomings or potential shortcomings. So to cut a long story short, at the moment, I think that as to scholarship, a reasonable, critical approach to institutions is to be developed. That we should be aware, for example, that even respectable Western constitutions and institutions contain more than simply germs of illiberalism. Illiberalism is built into constitutions for historical reasons, also because they reflect social values, and at the time these constitutions were written, and even today, there are elements of illiberalism in society. And by that I mean intolerance and other disgusting things. They are built into the Constitution. In constitutions favoring freedom of religion, which I think is an absolute must, there is always a danger of moving to theocracy. In a constitution that guarantees democracy, there is always a danger that democracy will become a kind of unlimited power, and so on and so forth. So we have an institution that is just like democracy, is not perfect. It's perhaps the best what we can have, constitutionalism, in the context of constitutional law and state institutions. But it is just the best in the sense Churchill described democracy. It's you know, it's the only advantage is that this is the best among imperfect solutions. So that, I think, is crucial. And instead of that, you continue to see this traditional positivist adoration of institution and debates about the gritty-nitty, is this word meaning this or that? I understand the practical importance, but it does not prepare us to the increasingly harsh reality that we are facing with the emergence of illiberal trends. Not that this illiberal potential is not there, not in society, and it is part of what people wish, what institutions wish. But I think it has to be contained.
Very, very interesting also because there is the idea of suspicion and then also of distrust, that is not something that is going to destroy the relationship between individuals and state, but to inject some critical awareness in the individuals about which might be the abuses that are not always very implicit, they're not they're not always very evident, but sometimes they are implicit, sometimes are hidden. That comes the next question, because this is clearly a situation that is more common in Eastern European countries, and clearly Hungary. It's a great laboratory for abuse of power. But my question would be now, in relation to the issue of national identity and maybe constitutional identity as well. Now, there is a risk of contagious effect, of migration of constitutional ideas, in this case, from east to west, and more precisely, the Article 4, paragraph 2 of the Treaty of European Union, where there is that reference to constitutional identity, can in a way be a good bridge for such migration. How should be interpreted? Do you see a danger or a possibility in that provision in this context?
Well, I've written rather categorically against the use of the term constitutional and the concept of constitutional identity in judicial decisions. I find it an undefined and easy to abuse concept, which is not necessary for decision making. The idea that the word is there, so you can't disregard it. It's true. We know that it was an odd compromise. We also know that not everybody is an enthusiastic supporter of a more integrated European Union, and that's a reality. So although I, not only because I hope that this is the right path to have an integrated Europe, I mean, I don't think I have to prove it today when they are killing people in Ukraine, which is Europe. And anyway, even if it were not in Europe, it shows the importance of a strong, coherent, liberally committed entity in order to maintain world order based on values. But forget about this. The reality is that this is not the view of everybody. Still, legally, it's not a proper category because it enables abuse. It has no clear content. It is an opportunity for or an invitation for a nationalistic, short-sighted interpretation, both of union law and national law. So I have very serious reservations. At the same time, I accept that the original approach of the German basic law, which states some essentials which cannot be amended, that is, and you may call that identity. I'm not objecting to that. So that core is something that is worthy of protection. If you wish to call it identity, but then you specify this is what you mean, then okay, I understand that, and I can certainly live with it. But the problem with constitutional identity, or the identity as it's used in the treaty, that is not specific. And the way constitutional identity is used by a number of constitutional courts, so is not specific. It's a wishy-washy thing. So that is really the problem. That the treaty does not define it properly and does not limit to the essentials what makes Europe into what it should be. And so, the European court, the Luxembourg court, tried to come up with some formal elements, but that's related to rule of law, and I don't think that it is extremely helpful to cut back on the nationalist interpretation.
Thank you. And there is a follow-up question on this. Do you think there is the risk for some Western constitutional court? For example, clearly my mind is going to cut through in particular to be a bad master. I try to explain a little bit better. I mean, it's obvious that they are using constitutional identity within their context, within the constitutional frame. But I mean, it's a word. The words are not always neutral. They can be manipulated. They can be borrowed in a manipulative way. So there is a kind of special responsibility for such prominent Western constitutional court to avoid some language that could be manipulated, or is just a question that it doesn't belong in any case to the responsibility of the Western constitutional court. I'm clearly speaking about German constitutional court because it's the one that clearly focuses more on this identity narrative.
Well, you mentioned Germany. You could have mentioned the Italian Constitutional Court and doctrine, where the fact that statute of limitation is substantive criminal law versus procedural criminal law is elevated to this. So I mean, Italian constitutional law, depending on whether this is substantive or not, I know that people are ready to die for so many things, and at the times of Byzantine iconoclasts, and homoousion, homoiousion, was the source of, I don't know, maybe 200 years of internal war. So these things happen. In going back to your specific question, again, you have to put this in a context. In many respects, courts have ego. And this identity issue was, to a very great extent, a matter of ego. Which court is wiser, more excellent in protecting certain values? And then there might be a slight difference in values or style of judicial reasoning. So that was a little bit unfortunate ego trip. With some important consequences, but for the time being, at the end, the way this was solved tells a lot about how serious the conflict was. There was always ready to compromise and just show that you have that you roar, so you must be a lion, but you don't eat the gazelle. And anyway, you don't know who the gazelle is in these stories. But the potential is there, and a lot of energy was spent on it, a lot of unnecessary tension. So I think it didn't help much, although those who participated took it extremely seriously. And I know that just from my past experience, once you get into some kind of dogmatic debate related to a case, it's nearly impossible to get out of this. So you take it for granted and you really fight for homoousion or homoiousion. So it's easy to say from the sidelines that okay, the game was not that interesting. If you are on the in the match, just following the ball, you have a very different sense of the reality. So, from the external perspective, it didn't help much. That's all I can say.
Very clear. Now I would like to move to something that looks different, but in a way is very connected to what we have said until now. Because at the end, we started with the idea of DNA of constitutionalism is limiting powers, and clearly the idea at the beginning was limiting public powers, and it's obvious that this is the one of the let's say prevailing focus. But since you are also a very, let's say, acute and prominent scholar in relation to the issues related to the relationship between law and technology. There is another maybe challenge for constitutional law now, no? Limiting private powers. That is clearly not something new, because there are many private powers that in the past needed to be limited. But clearly, in terms of cyberspace, in terms of internet, those powers have, let's say, a huge potential to, in a way, frame even the public's discourse. So my question would be, if you see this kind of problems, and which might be a solution, just in order to be even more clear, the European solution seems to just focus on the enforcement of digital privacy as it would be the European First Amendment, whereas in the United States, you know very well that freedom of speech, in a way, is still the roadmap, sorry, the lodestar and the traveling compass in order to try to find the right balancing. So which is which would be your take in these kinds of, let's say, transatlantic match or transatlantic asymmetric perspective?
First of all, let me start by saying a few words on the privacy concern in Europe and what has been achieved. So I understand that there is a tremendous amount of abuse, although to what extent people really agreed to it is a different story. I always start with this example that there was a moment when I don't want to name a social media suggested its users that they shall determine the rules, and they were not interested. There were, even before that, business models where they guarantee that they will not use your private data. They will not provide the private data for commercial purpose in the sense of facilitating or targeting advertisement, but you have to pay. And you know, the standard estimate is that you could generate the same revenue for these companies if it were on subscription, $30 or $40 per month. And people were not ready to pay $30 or $40 per month for their privacy. So I think that's a consideration. Now, after this kind of public choice of business model, population started to free ride. And they said, okay, I don't want to pay, but I want the regulators to intervene. And then the regulators intervene. Now, what is the consequence? I see no real difference. whenever I would like to read a page of a newspaper, I have to click certain things. I can opt out, but when I start to opt out, I really don't know anymore what on earth I'm opting out of or from. Nothing is coming out of that in protection. So they, and to what extent the data protection law really protects us from abuse, I don't know. Certainly you are bombarded by advertisement, although there are ways to filter it relatively easily with ad block. And I don't know who gets at the end of the day the data which will be abused. Generally, it's the law, it's the government, and the government has authorization to have access to that data, which is collected anyway, right? And that's where the real problem lies. And you know, all these judgments of the European Court of Human Rights regarding surveillance, it's not okay, but it's there. And Pegasus happens in every country. So we have a problem here, notwithstanding the protection promised. Second, okay, let's assume that there is a need to protection, but there is another aspect of protection. People using social media would like not only privacy protection, but protection against harassment. And here we reached a very difficult point which challenges traditional assumptions of freedom of expression. So it's not just a US versus European Union divide. It's much more than that. Traditionally, there were justifications given for the protection of freedom of expression. And centrally, this was about the interest of public discourse, that the statements are protected not only because this is a tool of self-fulfillment and finding the truth, but because it had a fundamental function in democratic will formation, right? Now, the problem with social media, internet, etc., is that the traditional borders, which were not so clear anyway, between public and private, disappear. And if this is purely private exhibitionist speech on strictly personal matters, are you beautiful, are you not, then it's not clear that the traditional reason to protect freedom of expression is still there. Okay, but we know also that these remarks, which are socially still important, although individualistic and even harassing, they are also part of a public discourse very often. So take all this crap about COVID-19. It's not just crap, because there is enormous uncertainty, and democracy allows and requires people to have their voice. So yes, it's not a particularly great idea to allow spreading news about chips being implanted. That's cannot be justified by the idea of truth. But imagine the debate about, for example, lockdown. Okay, is lockdown helpful or not? Is lockdown helpful or not in a specific city with a specific known level of contagion? Is a debate about the level of contagion is permissible when you challenge government data for good reason in many countries? Are you allowing that debate? That is public debate, although it is about how idiotic X is, or even is full of lies at the same time. So this is even more blurred. We lost the advantages of hidden censorship, which exists in a newspaper, right? We call it editorial responsibility. Of course, this is censorship. But as a social institution, for a social institution like the press, and for public communication, it had a sanitary effect. Now, this kind of censorship is gone. And then the state is unwilling and unable to take a position. And they basically privatize the regulatory function. They contract it out. They don't want to take a position. They say, okay, you're rich, you know the thing, so you do it, a company or corporation, bloody multinational on top of that. So even less trustworthy. It is not exactly a fair reaction. You don't take the responsibility, but you impose obligations without clear guidance. What is harassment? It's not defined in the Digital Services Act. Illegality, right? Unlawful content. Okay, then you refer back to national law with unlawful content. Then you have 27 different unlawful contents plus another 200, no, another 150, because all the other countries, which are not EU countries, but the companies have to follow that all over the world. So what is illegal? And they don't want to define, perhaps because it is impossible to define. And then you have uncertainty. And when you have uncertainty, you have, of course, censorship.
I see this point. It's in a way, it was also part of your very powerful narrative in the some dissenting opinion, European Court of Human Rights. I mean, it comes to my mind Delphi, but it might be also others in which you were absolutely pointing out to the risk to neglect the collateral censorship. No, so this it's very important, and I think this would be a great final for us, because in light of your, let's say, guidelines, in the light of your suggestions, in a way, it's very important to frame, a narrative that, in a way, should incorporate a lot of, let's say, of cautions in order to avoid what you said is simplistic antagonism between the United States and European legal orders. So this is, I think, it's a very important point. I would like to end this, at least for me, very, very pleasant conversation with a question that, I mean, it would require what's a very short answer. Now, which will be your next project? Or, I mean, I don't want to speak in pragmatic way, in a pragmatic way. Which are the ideas that now are in your mind in relation to a possible scholar challenge, the next scholarship challenge for you?
Well, currently I moved into a more theoretical project, try to consider what is these days called the social norm theory, the applicability of that to lawmaking, legal reactions. So it's basically how people react to law in the empirical sense. So it's not really a legal dogmatics thing, although I will certainly follow that to some extent. But at the moment, this is my main interest, perhaps because, well, it perhaps reflects the difficulty I have to come up with practical solutions regarding the current backlash and difficulties we are facing. I'm not running away. I keep an eye on that. I have a parallel project, but you asked me for a short answer. So the short answer is norms, social norm theory applied to law.
Thank you very much for this, Professor Sajó. Thank you very much, András, for this really nice conversation. We start this Friday morning in the best possible way. So thank you very much. And I also wish you a nice morning, a nice afternoon. And I hope to be in touch soon. We will be, because as you know, I will involve in Bocconi and in many other projects. Thanks very much for your patience, for your support, and for your cooperation. Thank you very much.
Thanks for the opportunity. All the best.
Thank you. Bye-bye.
Bye-bye.